Good afternoon. Welcome to Division 6 of the Colorado Court of Appeals. I'm Judge Dunn. I'll be presiding today, and sitting with me today is Judge Furman on my right, and we have the pleasure of Senior Judge Marquez on my left. Have counsel all received instructions regarding our oral argument procedures?
Yes, Your Honor.
Any questions? No?
No, Your Honor.
All right.
Your Honor, we mark out, and we do have a question regarding the allocation of time between the two appellants, whether the court would be willing to set the clock, two 10-minute clocks rather than one 20-minute clock.
I believe, bailiff, can we do that? All right. We'll go ahead and set that. We understand that you've been granted extended argument, and we'll set it for 10 minutes. And how you allocate that, though, is between counsel. We ask counsel and any visitors today to please turn off any electronic devices. If they are on and silenced, it still interferes with our recording equipment. Also, as you may know, we are now live streaming arguments, and they will also be available on our website. So if there is anything confidential or sensitive, please conduct your argument accordingly. I believe that is it. I understand that you have an exhibit and that it has been shared and approved by opposing counsel. Is that correct?
Share, yes. We haven't had communication regarding approving, but we certainly informed opposing counsel of the exhibit.
And use during oral argument?
Pardon?
And the use during oral argument?
Yes.
Any objection?
No objection.
All right, then the case may proceed at your pleasure.
May it please the court, my name is Lou Harstead, and I represent one appellant, the Cordillera Property Owners Association, which is often referred to as the CPOA or the association. Of the association's 10 minutes, I would like to reserve 3 minutes for rebuttal. This is a land use case. It's about whether or not a proposed use is a use by right in the subject PUD. The decisions of the Eagle County Board of County Commissioners and the Eagle County District Court must be reversed for 3 reasons. First, the board erred when it determined that an inpatient use is not a use by right in the PUD, but then inexplicably determined that the proposed use, which had been described by CCG, the Community Development Director, and everyone associated with CCG as an inpatient use, yet the board somehow determined that outpatient use to be an outpatient use that was allowed in the PUD. Second, the board erred in failing to examine the legislative intent of the operative provision of the PUD when, 1, the county code requires any interpretation to examine the purpose of the language being interpreted, and 2, the commissioners acknowledged the ambiguity but refused to examine legislative intent. And third, the trial court erred in not allowing the association to amend its complaint to assert a claim for declaratory relief when evidence that the proposed use violates the board's interpretation emerged after the close of briefing on the 106 appeal. With regards to the first argument, no one disputes that inpatient uses are not uses by right in the Cordillera PUDs. The appellees conceded as much in their answer brief. So the issue on appeal is simple. Is there any competent evidence that CCG's proposed use can be considered anything other than inpatient use? This case, from its inception, has always been about whether CCG's proposed inpatient treatment facility is a use by right in the Cordillera PUD. The case initiated when CCG requested an interpretation from the county's Community Development Director as to whether or not a inpatient treatment facility is a use by right in the PUD. CCG's principal made clear that that CCG needed this interpretation in order to obtain a license from the state of Colorado, quote, to provide residential treatment / inpatient services, end quote. That's at CF 837.
Yeah, can I ask a question? I'm curious as to why you're making the inpatient argument when the board decided it must be outpatient.
Because the board first determined that inpatient uses cannot be a use by right under the PUD. And there is no competent evidence in the record to indicate that this uses anything other than an inpatient use.
Well, the board has decided it's outpatient, and if it turns out to be inpatient, don't you have some other remedy?
But that may be the case, but this is a request for interpretation based upon a record that was before the county commissioners, and there was nothing in the record, no competent evidence in the record that this was outpatient in nature. All of the evidence in the record indicates that this was inpatient. The request for interpretation requested an interpretation that inpatient facility is a use by right. That was the director's determination that an inpatient use is a use by right. CCG's principal, attorney, agent, everybody described it as an inpatient use. At the hearing, everybody described it as an inpatient use. It was never considered to be an outpatient use, and the issue was never even raised, but for one leading question of a county commissioner. And even then, the question was, it was at the very end of the hearing. It was page 177 of a 194-page transcript. And the question that the commissioner asked is whether CCG's clients would, quote, be treated in an outpatient setting, end quote. CCG's principal answered, correct, but he did so on the basis that CCG intends to operate a single facility, quote, with differentiated portions of this facility, end quote. That's it. That's the only evidence that the commissioners relied upon to determine that this was an inpatient facility. There's no competent evidence, rather, and I can walk you through the evidence that was emerged in the record as to why this was an inpatient facility. So with regards to the issue that was before the board itself, they were asked to affirm an interpretation that an inpatient facility is a use by right. And there's no competent evidence that this was actually an inpatient facility. I think when you fundamentally look at the record, all of the evidence indicates to be a patient, one has to be a resident. To be a resident, one has to be a patient. It defies logic to call this anything other than an inpatient facility. Given the limited time here with regards to the second and third arguments, I'll refer the court to our briefs for additional arguments, and we'll entertain any other questions or otherwise reserve our time.
All right, you have 4 minutes and 14 seconds for rebuttal.
Thank you, Your Honors. Good afternoon. My name is Tom Wilner, and I represent the individual Cordillera homeowners in this case. Let me say at the beginning that we agree with Mr. Harstead's argument that this use is an inpatient use. That's how they always described it, and they just shifted labels at the very end when they said they couldn't have inpatient use. But we, as Colorado property owners, we have an additional and distinct argument that we want to make. We're here because the district court's dismissal of our Rule 57 claim was contrary to the settled decisions of this court and the Colorado Supreme Court. Those decisions make clear that as Colorado property owners, we are entitled to clear, unambiguous notice before changes may be made to our zoning. And we're further entitled to a declaration that any zoning amendment adopted without such notice must be declared invalid. That's the law, and we've been deprived of those rights so far. Really, our case is very straightforward. In October of 2016, the Board of Commissioners, which are called the BOCC, for the first time determined that a 2009 amendment to the Cordillera PUD had substantially changed the PUD to allow the lodge and spa to be eliminated and replaced by more than 30 other so-called standalone uses. If that were really the purpose of the 2009 amendment, we as Cordillera property owners were never notified of it. Indeed, we were told just the opposite, that that amendment was not going to substantively change our PUD. Now, I know rather largely we put up the notice that was sent to each Cordillera property owner at the time, and this is what it said. And may I just say something too, because I think there's a different paradigm in a case like this. This isn't a case where you're interpreting a complicated contract in a dispute between two organizations or two corporations. What we're talking about here is the right of individuals, unrepresented individuals, to be informed of governmental action being taken upon them. And that's why this state has made so clear that notice has got to be given clearly and unambiguously so the layman can understand the impact on it. This is the notice we were given. The notice said the proposal does not introduce new or additional density or uses to the existing PUD or otherwise substantively change the existing PUD. And it goes on and says this treatment reflects existing development and the contemplation completion of the lodge at Cordillera. Based on that notice, no one objected to this amendment. No one even went to the hearing because of it. And no one looking at this notice had the least hint that there was a possibility this amendment was intended to allow the replacement of the lodge at Cordillera, which probably would have been the most substantive change you could have made to the PUD. The BOCC's determination that the amendment had done that was simply contrary to the notice it had provided. Accordingly, promptly after it made its decision in October 2016, we filed a complaint in court and we included a claim under Rule 57 saying that if the amendment is interpreted that way, is so interpreted it should be declared invalid. We never had the chance to pursue that claim because the district court tossed it out on Rule 12b-5 motion to dismiss at the beginning. I believe that was clear error. The court did it for two reasons. It said, first of all, that this is not the appropriate vehicle to raise such a notice claim. And the court was flatly wrong in that. It's directly contrary to the decision by the division of this court in Russell v. City of Central. I always difficulty saying that. City of Central, which said, and I quote, "Declaratory judgment is the appropriate means of reviewing notice and due process claims with respect to the validity of a site-specific rezoning action such as this." Also, the Supreme Court in the Hallmark case, Hallmark v. City of Goodiston, invalidated a rezoning amendment for improper notice, inadequate notice, under Rule 57 in remarkably similar circumstances to those here. I can go through the case, but it's quoted throughout the brief and talked about. So clearly, Rule 57 is the appropriate way to do this. Secondly, the court dismissed the claim saying it was barred by the statute of limitations. The court said it was barred by the statute of limitations because it said the statute of limitations began to run in 2009 when the amendment was originally adopted, rather than when the interpretation giving rise to the claim occurred. There's several things wrong with what the court did in this statute of limitations. First of all, when a statute begins to run under Colorado law, when a plaintiff knew or should have known that the claim existed, is a factual question. As the courts have said time and time again, it's not appropriate for a motion to dismiss unless the facts are undisputed, and they were not here. So the court didn't treat this as a factual issue. It made no factual finding that homeowners should have known of this claim or that this would be that this notice would be ignored and that they were going to interpret the amendment to allow the lodge to be replaced. They had no idea. The court made no finding of that. Rather, the court determined as a matter of law that they should be held to constructive notice of any interpretation from knowing that the amendment existed. And that makes no sense. There's absolutely no court support for that. And let me just say, and then I'll finish. As a practical matter, the statute of limitations could not have begun to run before October 2016. Homeowners couldn't have brought a claim before then. It's clearly a statute of limitations can't begin to run before you can bring a claim. Couldn't have brought a claim in 2009 or 2010 or 2011. What would we have said? We said, please, court, declare that the board cannot at some unknown time in the future interpret this amendment differently from the way they explained it to us in 2009, even though we have no indication that they're going to do that. Any claim brought before 2016 when the cause of action arose would have been considered premature. We couldn't have brought it.
Aren't you asking for an interpretation, though, under the declaratory judgment action, and that's what you get under 106A4 proceeding?
No, we're not asking for interpretation of the amendment. We're asking for a declaration that if that interpretation is correct, then the interpretation is directly inconsistent with the notice was provided and is therefore invalid. We
So
want a
you're-
declaration of invalidity if the interpretation is correct.
So you would concede that it is correct?
I don't consider it's correct. I actually think, this claim says conceding that it is correct, it is invalid because it is inconsistent with the notice that was given. And that's the law. You cannot adopt an interpretation of an amendment to zoning amendment inconsistently with the notice provided to homeowners. If it is invalid. And let me say, because I don't know whether I'm going to get a chance for a rebuttal, it's remarkable to me that the law establishing this, the Holly case, the Hallmark case, the Whately case, they don't even mention. It's not even mentioned. It's just they ignore the law. They think that'll make it go away. But that's the law. An interpretation of amendment inconsistent with the notice that is given is invalid. And that's to protect us. Your Honor, how can anyone have known from this? We have a right to comment in a public hearing on an amendment, and we need to know what that amendment is supposed to mean. And the notice provisions are so that we as homeowners can comment on that. I'd really love to reserve the rest of my time, if I may.
Thank you, Mr.
Thank you.
Wilner.
Good afternoon, and may it please the court. Thank you all for being here and listening to argument on this case today. My name is Brian Connolly. I'm with the law firm of Ott & Johnson, Robinson, Neff, and Raganetti, and I'm here on behalf of Behringer Harvard Cordillera LLC. Joining me at council table is Brian True, the Eagle County attorney, and Sarah Baker, also for Behringer Harvard. I'll be presenting oral argument on behalf of both of the appellees in this case today. In February of 2017, Judge Jackson of the U.S. District Court for the District of Colorado entered an order denying a motion for preliminary injunction in a case that was very similar to this one. The plaintiffs were residents of Cordillera. They were represented by the same counsel as the counsel for the Benson plaintiffs today. And the case was based on a very similar set, in fact, an identical set of facts and circumstances as this one. And while the particulars and the disposition of that case are not important to you today, that Judge Jackson identified what Cordillera residents' real problem was with the underlying interpretation in this case, which was that it would allow the lodge and spa at Cordillera to be used for people who are recovering from drug and alcohol addiction to live there and to receive treatment there. And that's what this case is really about. The record reveals it, the briefing reveals it. And so while that palpable discrimination should alone be sufficient to deny the plaintiffs their claims in this case, Colorado law inarguably supports the defendant's position. The plaintiffs have used a series of shifting arguments, from first arguing against the clear direction of their community declaration that the lodge was entitled, or that they were entitled to permanent use of and access to the lodge, to now arguing about notice that was given in connection with a PUD amendment that preceded this interpretation by 7 years. Their arguments are not cognizable under the law. Their arguments have been dissected and rejected by the board, by the district court in this case, by another division of the district court, by the federal district court, and by the 10th Circuit, and they've lost at every step of the way. So today, we are respectfully requesting that this court affirm the district court in all respects. I'm going to spend a few minutes talking about their respective Rule 106 actions, and then I'll move into their declaratory judgment actions. So the plaintiffs don't dispute that the board's interpretation of the PUD was a quasi-judicial act. Thus, Rule 106 applies. Under the standards set forth by this court and the Court of Appeals in Alpenhoff versus City of Uray, in City of Commerce City versus Enclave West, in Anderson versus Board of Adjustment, and many other cases, interpretations by a zoning board of its own regulations are entitled to great deference so long as they are reasonable. It does not take much to conclude that the board met this standard. Section 2.01.1 of the PUD contains a list of 34 independent permitted uses on the lodge parcel. 2 of those uses include residential uses and then medical uses. The board determined that inpatient uses, that is, where a resident receives medical treatment within a particular residential unit, would be prohibited. It easily concluded, as it must by the plain language of the PUD, that a facility in which residential uses and medical uses were operated separately from one another was consistent with the use permissions of the PUD. Indeed, the board reviewed plans and heard clear testimony at its September 2016 hearing that articulated the layout of this facility and how these 2 uses would be separated from one another. Now, it doesn't require an inquiry into legislative intent to arrive at this conclusion, but even the background of the PUD's amendment supports the board's interpretation. Plain language is the best indicator of legislative intent. That comes from many decisions, including most recently State versus Nieto. And the PUD clearly allows residential and medical uses on the parcel, and the board found as much. But looking beyond the plain language, 3 items in particular confirm the intent to allow both of these uses. First, the PUD amendment in 2009 clearly deleted the requirement that any ancillary uses accompany the clubhouse and lodge. A quick comparison of the pre- and post-2009 PUDs lays this bare. Before 2009, the PUD allowed 2 uses on the lodge parcel. One was clubhouse and lodge uses. The second was utility facilities. A list of ancillary uses was enumerated underneath the clubhouse and lodge use. Looking at the post-2009 PUD, it shows the clubhouse and lodge use to be co-equal with 33 other permitted uses on the lodge parcel. What's more, the including but not limited to the following language, which tied the clubhouse and lodge use to those ancillary uses, was very purposefully deleted, and in fact a red line was supplied in connection with the amendment that showed that deletion. The second piece of background that supports the legislative intent is that the CPOA and its lawyers reviewed that document. They were required to because the 2009 amendment was a major amendment to the Cordillera PUD, and the CPOA is required to review major amendments. Their lawyers reviewed it, their board approved it at a public meeting, and so therefore they consented to this language. And Behringer Harvard made it abundantly clear, as shown on the notice, that its plan was to treat the lodge and village center parcels identically by allowing the same uses that were allowed on the village center parcel on the lodge parcel. That's not highlighted on the board, but it's there. Third, and perhaps most indicative, is the Cordillera Community Declaration. It's the declaration of covenants, conditions, and restrictions that was approved and recorded at the same time that the original PUD was. Section 2.3 of that document states in no uncertain terms that no representation or warranty is made regarding the ongoing operation of the lodge. And it goes on to say that the lodge owner may, quote, terminate use rights altogether. As Judge Jackson said in his order, quote, I know of no authority that would permit me to force Behringer Harvard to continue to operate the lodge in the face of that declaration. The analysis under Plaintiff's Rule 106 claim is cut and dried. They want the court to substitute its judgment for that of the Board of County Commissioners, but the board itself was obligated to reasonably interpret the PUD, and the court should provide great deference to the board's interpretation. Now I'll move on to their respective declaratory judgment claims. Because the facts and law of this case make it virtually impossible for them to prevail on their Rule 106 actions, each of the plaintiffs have attempted to confuse and obfuscate this matter and go outside of the record by filing a series of declaratory judgment claims, and the district court properly dismissed both of them. The Bensons have filed a declaratory judgment claim regarding the 2009 PUD amendment. Now, I'd first note that it's not really clear what they're asking for. In their first amended complaint, they sought to invalidate the amendment as interpreted, which essentially sought the same relief that they seek in their Rule 106 action. And they reiterated that request in their briefing before the district court. Now, on appeal, they apparently seek to invalidate the entire 2009 amendment based on the notice that was given. Neither of these attempts is cognizable under the law. I want to make two initial points regarding their notice argument. The first is that the notice itself is accurate. It says very clearly that the same uses that were previously allowed on the Village Center parcel would be allowed on the Lodge parcel. That's exactly what happened. The second point I would make is that the reason we are even here discussing notice in the first place in the context of a declaratory judgment claim is because issues of notice were not raised before the Board of County Commissioners in September of 2016. The plaintiffs were there. They had the opportunity to raise issues of notice before the Board of County Commissioners, but they didn't. So the Benson's declaratory judgment claim asks the court to analyze notices associated with the proceedings in 2009 to amend the PUD. And I would point the court to the Supreme Court's decision in Sundance Hills Homeowners Association versus Board of County Commissioners, in which it talked about the purpose for notice, which is to give adequate warning to neighbors, quote, so that they may appear and have an opportunity to be heard. There's no suggestion anywhere in the law that a notice must contain an exhaustive description of the action that's being taken. And I'd like to take a moment and talk about the Hallmark case that Mr. Wilner referenced. Hallmark dealt with a situation where the notice that was provided in the newspaper did not even state that the action that was being taken was a rezoning. This notice very clearly says, in the first line, the purpose of this planned unit development amendment. It tells you what action is being taken. And the case law in our state says that to be a proper notice, it needs to say the date and time of the hearing, the location of the hearing, and a brief description of what the action is. This notice satisfies that.
So, Mr. Conley, is it your
Yes.
contention that the 2003, the permitted uses for the village parcel, there's 21 permitted uses. So the notice there that suggests they're going to be aligned in 2009 was sufficient to put the homeowners and the association on constructive notice that there were additional permitted uses that were going to be added to the lodge parcel?
So I think there's a twofold answer to your question, Your Honor. The first is that I do think this notice is sufficient to put the homeowners on notice that there was going to be a PUD amendment considered, and it does say that the uses that were on the Village Center parcel would be transferred to the lodge parcel. What I would also say is that under the Supreme Court's decision in South Creek Associates versus Bixby and Associates, a homeowner or any property owner is deemed to have constructive notice of any zoning action that is applicable to their property, and that case in particular dealt with a PUD. So even once this PUD amendment was passed, Colorado law says that property owners then have constructive notice of the amendment that has been passed. So the notion that 7 years later they just discovered this is just not correct under the law of our state. So the Benson party's challenge is limited. They do not allege that notice wasn't given, but rather that the substance of the notice provided insufficient detail. Their claims are improperly brought for three reasons. First, a party can only bring a declaratory judgment claim where Rule 106 review would have been an inadequate remedy. This court held that in Meyerstein versus City of Aspen and Native American Rights Fund versus City of Boulder. What the Bensons ultimately want is a reversal of the board's interpretation, which is identical to what they seek under their Rule 106 action. So on that basis alone, the district court was correct in dismissing their claim. The second part of that, though, is that this court also held in Meyerstein that a declaratory judgment review of notice issues is only appropriate where notice wasn't received and the party had no opportunity to participate in the hearings. The plaintiffs have made no suggestion that they didn't have the opportunity to participate in the hearings, only that they read the notice and chose not to attend. So again, under Meyerstein, declaratory judgment should not even be cognizable. And the third point is that even if declaratory judgment were appropriate for reviewing the adequacy of notice, such a declaratory judgment action is required to be brought within the 28-day jurisdictional deadline under Rule 106. And Russell versus City of Central, the case that the plaintiffs rely on for the notion that they should have a declaratory judgment claim here, says just that. And this court confirmed that requirement in JJR1 LLC versus Mount Crested Butte. So even if the plaintiffs could bring a declaratory judgment action to challenge the substance of the notice in 2009, it had to be brought within 28 days of that decision, not 7 years later. Even if for some reason a declaratory judgment claim could be brought outside of the Rule 106 deadline, which it cannot, any statute of limitations to challenge that has long passed. Benson's argument regarding their lack of notice of a PUD amendment is baseless. As I noted earlier, The Supreme Court has held in South Creek Associates versus Bixby and Associates that property owners are deemed to have constructive notice of a PUD that encumbers their property. And this court said in Olson versus State Farm that ignorance of the law does not expand or excuse the statute of limitations. What's more, the CPOA itself reviewed the 2009 amendment, and neighbors had several opportunities to comment on and provide input on it. The Bensons seek a dangerous precedent with their notice claim. If a property owner could challenge notice given in connection with a zoning amendment many years later, anytime a formal interpretation is issued, that would mean that no property owner and no local government would have any certainty in any zoning classification that applied to his or her property. Finding in favor of the Benson parties would put every zoning classification in the state of Colorado in flux. That clearly contravenes this court's observation in the recent case of Auxier versus McDonald that the entire reason for prompt Rule 106 review is to remove local planning and zoning decisions from a post-approval cloud of uncertainty. For these reasons, the court should affirm the district court's dismissal of the Benson's declaratory judgment claim. And I do want to make one other point in response to Mr. Wilner, which is that he talks about the elimination of the lodge. The lodge has not been eliminated. The building is still there. What he objects to are the people who will be in the lodge. And that's what his notice claim is about. Now I'll move on to the CPOA's request for declaratory judgment, which Mr. Harstead did not cover, but that relates to what the CPOA considers new evidence that emerged after the hearing. The district court correctly determined that the CPOA's declaratory judgment action was unripe. Their argument pertaining to purported new evidence implies that they don't really even understand what this case is about. The Board of County Commissioners was not being asked to give a thumbs up or thumbs down on a land use application. Instead, it was being asked to interpret the PUD, to determine whether a treatment facility that contained residential units and a separate clinical office, which was depicted in conceptual plans that were presented to the board, would be allowable under those use restrictions of the PUD. The board determined, consistent with the plain language of the PUD, that an outpatient facility was permissible. Third-party, subsequently corrected publications don't change that conclusion. The relief that the CPOA wants, which is to prohibit an inpatient treatment facility in Cordillera, was exactly what the board granted it. If the treatment provider engages in treatment, in inpatient treatment, the county will be able to enforce the PUD against that treatment provider. So CPOA's new evidence argument is just not properly brought in the context of a situation where the board was interpreting the PUD. Finding in CPOA's favor on that claim would also upend well-established law, which holds that the court must grant substantial deference to the board in this case. The CPOA essentially argues that the court should not defer to the board, but instead defer to a Denver Post article and an SMB Bradley circular, third-party publications. And those parties, by the way, were not parties to this action. They did not attend this hearing. So under the CPOA's rationale, anytime a third party publishes or says something about a case after it's approved, that would be sufficient to reverse a hearing board's decision. That's not what the law provides, and you should not allow that here. So I thank you for your time, and we respectfully request that the court find in favor of the defendants, and I'm happy to use any of the remainder of my time to answer questions.
Thank you, Mr. Connolly.
Thank you.
Mr. Harstead or Mr. Wilner?
I want to address a statement about what this case is about. This case is about land use law. The record has clear evidence that the association made it clear that they welcome people with disabilities. That's at Court File 202, 203, 513, 678, 907. This is a land use case. The association was not a party to a federal court case with Judge Jackson. The association is here exercising its right under Colorado law to appeal the board's Rule 106 interpretation. That's why we're here. And this is the association's first and only day in court. So we do appreciate you in listening to the association. We haven't had a day in court yet. It is true, as appellees note, that the board's interpretation of a zoning ordinance is entitled to deference. That is accurate. But a reviewing court, including this court on appeal, is not bound by that decision if there is no competent evidence to support it. And here there is no competent evidence to support the board's determination. The board's attempt to bifurcate CCG's proposed use into separate and distinct medical and lodging uses is an artificial distinction. You just heard it from the appellees. It's not supported by competent evidence. Not a single representative referred to the proposed use as an outpatient medical office facility. Nowhere in the record. It's not cited in the briefs. Not the county's, not Behringer Harvard's, not CCG's principal, attorney, agent, doctor. No one called this an outpatient facility. To the contrary, CCG made clear at all times throughout this entire matter that it intended to operate an inpatient residential treatment facility. They made that clear at the time they sought the interpretation, court file 816. They made that clear in all of the arguments and submissions prior to the public hearing, court file 827 and 962, which in fact CCG's attorney stated just days before the hearing they intended to operate an inpatient facility. As I stated earlier in response to Judge Marquez, all the arguments at the public hearing were that this was going to be an inpatient treatment facility. The characterization of outpatient treatment arose from a single question, as we discussed earlier, and that's hardly evidence of an outpatient use. At most, that testimony demonstrates that CCG's medical and residential components will be provided in separate locations within a single facility. And that's evident by the quote. You can see this is a defined area of residential and this is a defined area of the clinic. That's a label. This is labeling over substance. And that label is false. Far from segregating the proposed residential use from the proposed medical care services, CCG's principal made clear that CCG intends to, quote, meld, unquote, CCG's provision of residential and medical services. That's in the court file at 472, 473. CCG's attorney made clear that the residential component will only be accessible to individuals receiving medical care from CCG. That's at court file 963. Quote, the lodge itself must remain as a private and controlled environment for the people being treated there, unquote. The lodge is a controlled environment for people being treated there. That's CCG's attorney. The single fact remains, to be a patient, one must be a resident. To be a resident, one must be a patient. There can be no clear evidence of inpatient use. The inconsistent treatment of conflicting evidence is arbitrary and capricious. I'm running out of time, so I'm going to talk quickly. This is like the brass monkey case that's cited in there. In the brass monkey case, the city of Louisville attempted to rely upon 26% of a survey data while disregarding the other 76% of that data. That's the case here. They're trying to rely on one statement while disregarding the totality of the record. Thank you. We ask you to reverse.
Thank you, Mr. Harsat.
Okay, I will, by necessity, be very quick. Let me say at the outset, and I'm not going to go into it, this case is not about and never was about discriminating against people with drug addiction or alcohol addiction. It's not about forcing the lodge to keep the lodge open, and it's not about forcing community access. Those points are dealt with at pages 22 to 24 of our reply brief, and I refer you to them. This case is really, in our Rule 57 case, is about one thing: adequate notice to homeowners of changes being made to their zoning. That simply does not give notice to people that the lodge, that this amendment will allow the lodge to be replaced. That's probably the most substantive change that could be made to the PUD. Now, if it were really their purpose to allow the lodge to be replaced by more than 30 other standalone uses, that could have been said in one simple sentence in there. It could have said, this amendment also allows the lodge to be replaced by the 34 places, uses listed. That sentence wasn't there. Why wasn't it there? Either it wasn't there, Your Honor, because that really wasn't their intent, and they made this argument later to try to make a sale to somebody, or if it was their intent, why didn't they put it in there? It was very simple to do. Good lawyers could certainly have put that one sentence in there. It wasn't in there. All I know,
A medical facility was in there, was it not?
a medical facility was in there, Your Honor, but nothing in there said that this amendment is, can you, if you were reading that, and you're a great judge, could you possibly read that to say, oh, from this, I see that something can replace the lodge? Medical facilities were there. You could always have medical facilities to assist in the lodge. People in the lodge use medical facilities. The fact is, the replacement of the lodge is the key thing. Nobody complained about this amendment as it was written. Nobody. When they said they were going to replace the lodge, well over 100 people complained and went to testify. They didn't know that this allowed the lodge to be replaced. It was easy for them to have said it if they meant it. Why would they have not said it? The only reason could be that they didn't want us to object. It doesn't meet the strict standards of this state in providing people with clear, unambiguous notice understandable to a layman so they can protect their rights. This amendment should be struck down as so interpreted. Thank you.
Mr. Wilner. Thank you, counsel all, for your very helpful arguments today. This case will stand submitted and an opinion will issue in due course. That concludes our 1:30 docket. We will reconvene for our 2:30 docket at 2:30. Bailiff, you may announce the recess. Good afternoon. Welcome to Division 6 of the Colorado Court of Appeals. I am Judge Dunn. I will be presiding today. Serving with me today on my right is Judge Furman, and on my left is Judge Freyre. For those of you, and that may be all of you, who were not present for our first oral argument today, if you have any electronic devices, could you please turn them off? Even if they're silenced, they interfere with our recording equipment. Thank you. Also, as you may know, we are live streaming our arguments, and they will be available on our website. So if there's anything confidential or sensitive in your arguments today, please conduct your argument accordingly. Counsel, did you receive our oral argument instructions?
Yes.
Any questions about those?
I do have one question. I have the record on a tablet. Is it all right to do that?
That's not a problem. We only have one case today set for our 2:30 docket, so counsel, you may proceed when you are ready.
Okay. This case is both simple and complex. Many arguments are involved regarding technicalities in contract law, but at its heart, this case is about whether or not same-sex couples have the ability to access the same remedies at law as do heterosexual couples. There are undisputed facts that these parties were in a committed, monogamous relationship for 13 years, that they shared bank accounts and jointly titled real estate with rights of survivorship, that they did financial planning jointly, with a planner who assumed that they were married based upon their behavior in front of him, and that everyone in their community saw them as a stable, committed couple. There may be some debate about what they called themselves, but their actual behavior is not debatable. They wore rings, and both of them testified that they had gone through a commitment ceremony to each other. As with all common law marriage disputes that make it to the Court of Appeals, one person is now saying that they were not married. But what is different about this case is that these parties on their own filed a petition for divorce and then, at a different time, filed an executed separation agreement. In fact, the undisputed testimony is that Neil, who is contesting the existence of a marriage, is the person who asked for the divorce and is the person who drafted the petition for divorce. What is different about these parties is also that they were a same-sex couple. But what is spectacular about the separation agreement, and these are attributes of the agreement that were never commented on by the trial court, is that the included remedies, the things they agreed to do to dissolve their relationship, included remedies that are only available to married couples. People who are breaking up and can own joint property, but they don't agree to pay each other spousal support. They don't agree to issue a quadro, a qualified domestic relations order. Those are remedies that only married couples can give each other.
Counsel, I have a question about that because the court recognized that, but determined that they both agreed to dismiss that petition. The separation agreement was never filed with the court, and that Ms. Neal, the court credited her testimony that the reason that she agreed to the separation agreement to file the petition for dissolution was because she thought she had to. And I'm wondering, how do we treat that? Because that seems to be a weighing of the evidence by the district court, and can we change that in any way?
Your Honor, I think you can, because I think the court made a mistake. The court also found that the parties had an intent to divorce. And I would submit to you that you cannot have an intent to divorce unless you acknowledge the marriage first. Much of the evidence regarding, the mistake of fact and that I just did this by accident, first of all, comes from impermissible and inadmissible mediation communications. But what is also true is that the document stands for itself, and it's a contract. It was a binding contract. It wasn't a court order, but it was a contract signed by two people who represented to the world in that document, and Neil testified to that at page 47 of the transcript, she was asked, doesn't this document say that you were married? And she said yes. What is also spectacular about this case is that it would never be the situation that a straight couple would go to a court facilitator and basically be talked out of filing for a divorce. That would never happen. The question of, do you have a marriage license, would never be asked. And the whole point of a Obergefell is that the laws that prevented marriage between same-sex parties were void ab initio. It's as though those laws never existed. And if you would not ask that of a straight couple, why would you ask that of a gay couple? The order was troubling for several other reasons. The court jumped to the conclusions that were not supported by the facts or the record. For example, the minute order regarding the dismissal that Your Honor just referred to the court states, shows that the parties said, quote, there was no marriage. I directed the court to the transcript of 2/8/17 at page 25, lines 18 to 22 for that quote. But if you actually look at the minute order in the exhibits, the minute order doesn't say that. The minute order gives a reason for the dismissal being that the parties thought they would be able to implement their agreement between themselves without court involvement. Nobody ever says there was no marriage. The minute order does say there was neither marriage nor civil union license, but it doesn't say the parties said they weren't married. The trial court ignored that the petition was drafted by Neil, that it was filed well in advance of the filing of the separation agreement, that the documents were signed by the parties on different days under different notaries, that it called for remedies only available to divorcing couples. And the court never said that these documents were not binding. The trial court did give a plea to this court to set out some guidance on same-sex common law marriages, and I would like to echo that plea, because many of the indicia of marriage came out of the case of Lucero, which assumes one man, one woman, and it assumes indicia that just were not possible for same-sex couples prior to Obergefell, such as filing of joint tax returns, such as designating somebody as a spouse on a government form that only had husband and wife.
Well, sorry to interrupt. What is the standard of review? You took the position in the brief, if I recall, that it was a de novo standard, but now it sounds like it's more of a factual. I'm trying to figure out what the standard is that you're asking.
I think on some issues it's de novo when it comes to an application of law, and on other things in terms of interpreting the facts, it's an abuse of discretion, Your Honor.
Okay.
So I will just very briefly address a couple of the arguments that are in the reply brief. The first one being that parole evidence was not preserved as an issue. I would point the court to the case of Magnetic Copy Service versus Seismic Specialists, in which the Court of Appeals held that because it is a substantive area of law, that testimony that was taken regarding a contract, even though it was not objected to at trial, could still be ordered to be disregarded because parole evidence is a rule of law. The other side says that there was a mistake and that the contract should be rescinded, but ignores the law of mistake insofar that a unilateral mistake cannot be the grounds for a rescission of the contract. That the separation agreement can't be binding unless they were married, that's just not true. It's a contract. The reply or the answer brief does not address either the issue of contractual estoppel or the issue of promissory estoppel. Contractual estoppel being the principle that if you draw a contract and both parties agree as to facts that support the contract, you cannot turn around and deny those facts. And one of those facts is that they were married. And in terms of promissory estoppel, clearly my client agreed to dismiss the marriage petition for divorce based upon the agreement of the parties that they would abide by the separation agreement. And there was testimony that both of them did abide by the terms of the separation agreement, including Ms. Neal's testimony that she attempted to get a QDRO through and found out that she couldn't without a divorce decree. Your Honor, unless there's other questions, I would like to reserve the rest of my time.
Actually, Counsel, I do have a question. On the Lucero criteria now that the status has changed and Colorado's laws were deemed unconstitutional, do you consider the Lucero criteria now acceptable for same-sex common law marriage?
Well, yes and no. Part of Lucero said that conduct could also include behavior. And on that, I agree with the court. Because when you look at what is a marriage, you look at things like, do people assume the right or the obligation of support? Because that distinguishes a couple that's just living together and investing in property from a couple that is assuming the obligations of a committed married relationship. The place you get into trouble with in Lucero is the holding out provision being, hey, this is my wife. And as I argued in my brief, the problem with that is to say, if you're in a same-sex relationship, let me introduce you to your wife, is to make a political statement. And same-sex couples, like everybody else, some of them are politically active and some of them are very introverted. And it was occurring in a time frame where people could lose their housing, their jobs, their family relationships for being overtly and openly gay. So if the requirement of Lucero is that you have to say, hey, I'm married and here's my wife, that's a problem. But if the requirement of Lucero is that you hold your relationship out because of your conduct, as a result of your conduct, that you live in a committed monogamous relationship, that you assume the duty of support, which there was evidence that Neil had supported Hogsett for several years, and then she assumed a duty of maintenance following the breakup of the relationship. I think those indicia are extremely important. Thank you, Your Honors. I'd like to reserve the rest of my time.
All right, you'll have 4 minutes and 27 seconds.
Thank you so much.
Good afternoon, Your Honors. May it please the Court. Stephen Plog, Attorney Registration Number 29532, appearing on behalf of the appellee, who is not present with us today. Your Honors, aside from the, I will call them side issues related to evidence estoppel and the existence of a contract, the core issue at hand in this case is whether the trial court improperly ruled that there was no common law marriage between Ms. Hogsett and Ms. Neal. Appellee believes there was no judicial error on any of the issues in this matter. Under Colorado law, common law marriage is derived from the holding in People v. Lucero. Appellant is seemingly asking the court to disregard the requirements of Lucero. It could also be argued that appellant is asking the court to find that the essential elements of Lucero are not really essential, and that perhaps common law marriage can be found when one element exists without the others. Though I'm certain the court is extremely familiar with the dictates of Lucero, I will briefly cite the holding that a common law marriage is established by mutual consent or agreement of the parties to be husband and wife, followed by a mutual and open assumption of a marital relationship. To be clear, appellee is not arguing that there cannot be same-sex common law marriage. Likewise, appellee is not arguing that there cannot be a finding of a retroactive same-sex common law marriage in certain cases. What appellee is arguing is that the facts in this case do not support either conclusion as relates to Ms. Hogsett, Ms. Neal, and the evidence presented at trial. Lucero also indicates...
Counsel, sorry to interrupt. I want to ask the same question I asked opposing counsel. What's the standard of review?
In terms of the common law marriage issue?
Well, in terms of this case, is it de novo? Is it deference?
I believe it is deference to the court and the court's findings at trial, if I'm understanding the question correctly, Your Honor. So, may I proceed? Thank you. Lucero also indicates that mutual public acknowledgement of the marital relationship is not only important evidence of the existence of a mutual agreement, but is essential to the establishment of a common law marriage. In this case, as pled by the appellee and supported by the trial record, there was no mutual public acknowledgement of a marriage as evidenced by the witnesses, the evidence at trial. The key, as also stated in Lucero, is conduct. Appellant places a great degree of weight on a petition for dissolution of marriage and separation agreement filed not in this case, but a completely separate case that was voluntarily dismissed, after which she filed a petition for dissolution of civil union and then the underlying dissolution of marriage action at issue today. Aside from any evidentiary arguments tied into the December 1, 2002 alleged marriage date used by appellant or the parties in the petition for dissolution of marriage and separation agreement they signed in the prior case, testimony was conflicting, if not outright damaging to the notion that the parties were married on that date. Additionally, it should be noted that the parties filed their joint dissolution of marriage action or signed the documents regarding such at a time when they had either separated or were separating. Appellant argues that by signing the documents in the prior dissolution of marriage case, the parties agreed to a common law marriage. She also argues that based on the parole rule of evidence, among other things, that appellee should have been precluded from presenting any evidence regarding the issues of whether a common law marriage existed. This is wrong on various levels. Firstly, appellant seems to suggest that the mere signing of these documents referencing a past point in time as the start of a marriage is dispositive of whether a common law marriage existed. Such a suggestion discounts the fact that Lucero, in addition to requiring an actual or inferred agreement to be married, also requires people to walk the proverbial walk and talk the proverbial talk. It requires cohabitation and a mutual public acknowledgement of a marriage following the agreement. An agreement signed in 2014 or 2015 without the relevant conduct following or even leading up to the signing of that agreement does not a common law marriage make.
But Mr. Pogg, you would agree that it's some evidence that the trial court could weigh on how they viewed their relationship. Is that not accurate?
I believe it is evidence that a trial court could properly weigh in making a determination as to whether a common law marriage existed. I don't believe that that evidence is obviously dispositive of that issue, but certainly I have no issue with the fact that the trial court could review that
Just
evidence.
one piece in the mix of all the evidence presented. Is that your position?
A brick in the wall, so to speak, for the court to look at, yes. Furthermore, going to the issue of parole evidence, appellant seems to indicate that the parole evidence rule would supersede the dictates of Lucero. However, there's already case law supporting the notion that a document or agreement alone is not dispositive of the existence of a common law marriage. Thus, it was imperative and proper for the trial court in this case to hear and receive evidence tied into whether the parties met the dictates of Lucero. In fact, in her ruling, trial judge McLean referenced the 1997 Colorado Court of Appeals case, Whiten Hill versus Kaiser Permanente, 940 Pacific 2nd, 1129, for the proposition that the signing of a common law affidavit alone does not establish a common law marriage. In that case, the court clearly looked at extraneous evidence beyond the four corners of that affidavit. The same would hold true here. An affidavit of common law marriage is no more or no less an agreement than a separation agreement filed in the prior dissolution case, which the parties voluntarily dismissed, frankly, at the first sign of someone raising the issue as to whether they were married or not. It was not improper for Judge McLean to hear evidence beyond the separation agreement. Lucero requires such, and conduct matters. That separation agreement was signed at the end of, again, or if not, after the parties' relationship is ended. There was no, quote, followed by in terms of the conduct required by Lucero, meaning there was no real conduct or outward manifestations of a marriage prior to the signing of that document, and that is concerning. Appellee recognizes that the appellant believes there was conduct evidencing a marriage prior to the signing of those documents. That is a factual issue or argument decided by the trial court, whose findings should be given deference and not disturbed absent substantive error. There was ample evidence for the
Mr. Pogg, sorry to interrupt again. I'm going back to my earlier question. The question of conduct that evidences a marriage sounds like more of a legal determination to me.
I think the fact, and I may be wrong, that the conduct being necessary to determine a common law marriage is certainly legal or a legal conclusion to make. Nonetheless,
Credibility, I understand.
So,
but that's,
and if you can restate the question, Your Honor, I apologize.
the question of marriage, does this conduct amount to a marriage? Sounds more legal than factual.
I would state that it is a legal question, but that answer to that question is arrived at via the facts, if that makes sense. I understand what the court is asking.
Okay.
Again, appellee recognizes that appellant believes there was conduct evidencing a marriage prior to the signing of those documents, that to an extent was a factual issue or argument decided by the trial court, whose findings, again, should be given deference and not disturbed absent substantive error. There was ample evidence that the trial court to arrive at the conclusion that there was no common law marriage. Without going too far into the trial record, as it is my understanding that the court has or will review such, the core argument appellant seems to make is tied into common law marriage and same-sex people, is that same-sex people can be found to be married without the word marriage, wife, husband, spouses, married, or anything of the sort being publicly manifested. Appellant is seemingly trying to argue that terms such as partner and life partner are synonymous with wife, spouse, or married. There was no presentation of this being common in the same-sex community as trial. There was no expert, no documentation, nothing supporting such a conclusion, and it would be improper for me to state my opinions as to that because that's not part of the record, but there was nothing really presented about that at trial. That's something that has arisen in the briefs. Yet this is what appellant asks the court to not only believe, but to adhere to in making its decision. As set forth in our answer brief, this rationale, if adopted, could very well open the doors of litigation for not only same-sex couples in committed relationships, but conceivably heterosexual couples as well. It could potentially force people who never intended to be married or never walked the road of Lucero to be forcibly married because they were partners, domestic partners, life partners, significant others, or cohabitated without any intent or even indicia to walk down the road of the word married. Marriage is marriage and a relationship is a relationship, and there are clearly legal and factual distinctions tied into those. Obergefell rightly opened the doors of equal protection in allowing same-sex marriage throughout the land. It did not open the doors to bootstrap committed relationships without Lucero conduct into the realm of marriage. In one of her briefs, appellant stated, and even in this courtroom today, appellant states something to the effect of if we were dealing with heterosexual parties, this case wouldn't be at issue as to the common law marriage. I opine, or appellee opines, that appellant is suggesting that this case would just have been rubber stamped as a marriage given the separation agreement and that a court would have looked no further if there was a challenge. In White and Hall, the court certainly looked further, as courts must do in common law cases. Appellant is seemingly asking the court to ascribe a different standard for same-sex partners in terms of them only needing to be partners or domestic partners to be considered married. This affronts notions of people having a fundamental right to be married or not be married as set forth in Loving versus Virginia.
Mr. Pollock, excuse me. Maybe I misunderstood. Are you now saying or agreeing that Obergefell is retroactive?
And I had said that earlier, but to clarify, we're not objecting to or challenging the notion that Obergefell can be retroactive in a common law marriage case.
Okay.
What we're in essence saying is that that's great, but we don't have the facts here because under Lucero, you still have to have gone through the steps. We're changing, appellant's argument is essentially changing the steps or changing the behaviors that people might have demonstrated to do that, if that makes sense.
It does. Thank you for clarifying that.
Thank you. And going again to standards, a determination of whether a common law marriage exists turns on issues of fact and credibility, which are properly within the trial court's discretion. Going back to what I was indicating earlier, going to the facts of this case, there was no documentation indicating the parties were married prior to the filing of the first dissolution case. There were no witnesses testifying to a mutual assumption or holding out on the part of both parties as to a marriage. In fact, only one witness testified that she heard Ms. Hogsett use the term married, never Ms. Neal. No witness indicated Ms. Neal had held herself or the parties out as being married. There was testimony from both parties that Ms. Neal had expressed an opposition to marriage. There was conflicting testimony as to the date of marriage or there even being a marriage ceremony. In fact, Ms. Hogsett's written statement prior to the November 2016 hearing differed from her statement at court regarding the ceremony or who was even there. The evidence required by Lucero to find a common law marriage was lacking before and certainly after the parties signed the petition and separation agreement in the other case. Additionally, why the parties didn't use the term wife, spouse, or married during their relationship to an extent is irrelevant. They didn't, and that's that, and it should be noted that they could have. As the trial record indicates, they knew same-sex marriage was legal in other states, and they knew that regardless of whether they could indicate they were married on official documents, there was nothing precluding them from saying they were married in their private or public social lives, or in the cards and letters they exchanged among themselves and with others that were also part of the record. Going to the notions of parole evidence, a binding contract, and estoppel, Appellee states that there are certain defenses to these doctrines, one of which is mistake of fact. Given the conduct on the part of Ms. Hogsett after signing the separation agreement, it seems clear that she was mistaken and unsure as to whether there was a valid marriage, which is exemplified by the hasty voluntary dismissal by both parties of that first dissolution case. Also, as part of the record, her subsequently filing a dissolution of civil union action, which I might know also she listed a different date as the inception of that civil union. Then we have the filing of this case. The record indicated her filing her 2015 taxes as single, even though she claimed to be married. This abundant evidence also supports a conclusion that Ms. Hogsett did not believe a marriage existed and or that she was mistaken in her beliefs when she signed that separation agreement in the prior case, just as Ms. Neal did. As relates to enforcement of the separation agreement under doctrines of contract law, without a marriage, the court in this case, the district court, had no jurisdiction to enforce that contract. Ms. Hogsett could have filed a civil case, but there was no jurisdiction there. A separation agreement is enforceable within the confines of a marriage, and that was just not the case in this action. And I'm out of time and have nothing further. Thank you, Your Honors.
Thank you.
Well, I'm reminded of the line from Shakespeare, a rose is a rose is a rose. And a lot is being made of the idea that because they didn't call themselves wife or spouses, that they weren't married. But what really is marriage? Because that's what this court has to decide. Is it calling somebody your husband or your wife? I've done that at bars to keep people from hitting on me in my youth. I don't think calling somebody your husband makes them your husband. I think living with them, being committed in a monogamous relationship, offering support, living off of their support. I actually have a list of things that I think evidence a marriage. Jointly tiled property, beneficiary designations on life insurance retirement accounts, doing joint retirement planning. You don't do that with a roommate. That happened in this case. The listing of the other as a family or emergency contact in medical work or related documentation. Voluntary assumption of support. There are 2 cases that I cite in my briefs. Roommates don't owe each other duties of support, and that's case law that goes back almost 100 years. In Read the Marriage of Dwyer, there's no maintenance obligation if you're not married. Why would somebody undertake one unless that they understood that they were in a committed marital relationship? Neal testified she supported Hogsett for 5 years. And if you look at the remedies they agreed to in their separation agreement, hardly any of them are what you would expect for 2 adults who are not related to each other. They didn't divide their property according to the law of partition. That's what unmarried people do. They partition a property, and they divide it up based upon the capital contributions to the equity. Not in this case. They treated it as a marital asset and divided it equally. They called for a QDRO for the division of retirement assets. You don't do that with a roommate. Neal actually paid maintenance to Hogsett for months. I mean, per performance, why is that not a relevant fact here? The Wittenhall v. Kaiser case is distinguishable because people do things and sign documents to get benefits. And that was a case where they signed a common law affidavit so somebody could get health insurance benefits. It's not the same thing as a separation agreement where the parties, the entire focus of the contract is, we are married and here's how we're dividing our property. In terms of mutual public acknowledgement, I direct you to the testimony of all of the witnesses who all testified. They were a couple, they were committed, they lived together, they were loving to each other. Because that is all conduct by which they held themselves out as being married. And you have to wonder if the comments of at least one of the witnesses, and I believe it's page 58 of the transcript, where she blurted out, but they couldn't have been married because it wasn't legal. And if that's the factual background in which this relationship occurred, and it was, and there was lots of evidence that both of these parties were very reticent to talk about to their friends. There was one of Neil's coworkers didn't even know for years that she had a partner. Because people could lose their jobs. They just didn't wear it on their sleeves because they couldn't afford to. In terms of going to another state and getting married, why would you do that if the state in which you live doesn't recognize it? And in terms of filing a tax return, my personal experience as a divorce attorney is that people file tax returns not because of their marital status, but because of how they are going to get tax refunds or what's going to save them the most amount of taxes. But I will say this. Hogsett filed her taxes in 2015, months after the February dismissal of this case and the agreement that she would be receiving maintenance. It doesn't seem to me that if she had filed as a married, filed separately, that would have been very good for her chances of receiving the maintenance that she depended upon from Neil, because that would have resulted in Neil being audited by the IRS, which is, for most people, almost as scary as arguing in front of the Court of Appeals.
Counsel, I have a question on the tax issue. If Neil was supporting her for 5 years, did Neil ever list her as a dependent on her tax form during the time she was supporting her?
Your Honor, if you give me a second, I'll take a look, but I've had so many of these cases I cannot remember off the top of my head. I
Okay.
have the record.
Sure.
Just one sec. That's a very good question. I don't believe that the taxes were made in exhibit, Your Honor.
All right, thank you.
If I may address the court, if it helps, going back to trial, I don't think we ever got to the stage of exchanging financial disclosures. So I don't think that were tax records private, aside from the 2015.
Thank you both for looking.
I think that's my time unless you have more questions.
Yeah, all right, thank you. Thank you both, counsel, for your very helpful arguments today. This case will stand submitted. An opinion will issue in due course. That concludes our 2:30 docket today, and we will be in recess. Bailiff, you may announce.